नमस्ते, मैं अविचल दुबे न्यूज़ तक के इस लाइव शो में आप सभी का इस्तकबाल करता हूं। आज एक बड़ा फैसला सुप्रीम कोर्ट सुनाने जा रहा है और इस वक्त सुप्रीम कोर्ट में सुनवाई चल रही है। सेम सेक्स मैरिज एक्ट पर जो ये सुनवाई चल रही है, इसको लेकर गहमा गहमी मची हुई है कि क्या सुप्रीम कोर्ट सेम सेक्स मैरिज को अलाउ कर देगा। सरकार ने इसका विरोध किया है, सरकार ने सुप्रीम कोर्ट में इसका विरोध किया है और अब इस पर बड़ा जो फैसला है वो किसी वक्त आ सकता है। एक तरीके से उसकी बातचीत चल रही है सीजीआई वाली बेंच में, यानी कि चीफ जस्टिस ऑफ इंडिया DY चंद्रचूड़ की जो बेंच है, इसमें 5 जजों की बेंच है, उनके साथ 5 जजों की बेंच है और वो ये फैसला कर रही है कि सेम सेक्स मैरिज एक्ट यानी कि जो कानून है इसका क्या किया जाएगा। ये कानून को लेकर तो साफ कर दिया गया है कि कानून बनाना जो है वो सुप्रीम कोर्ट का अधिकार नहीं है, व्याख्या करना उनका अधिकार है। उसको व्याख्यायित करना यानी कि उसको डिस्क्राइब करना, कानूनों को डिस्क्राइब करना वो उनका अधिकार है और उसके लिए क्या प्रावधान किए जा सकते हैं वो सुप्रीम कोर्ट देखेगा। सुप्रीम कोर्ट में इस वक्त सुनवाई चल रही है और सुप्रीम कोर्ट में जो सुनवाई है वो एक बड़े फैसले को लेकर सुनवाई हो रही है। सेम सेक्स मैरिज को लेकर सुनवाई चल रही है। LGBTQ जो पूरी की पूरी एक समुदाय है, एक तरह से कह सकते हैं कि हमारे पास एक हिस्सेदारी है, उसको लेकर जिस तरीके से अप डाउन्स जो है बने रहते हैं और अब जिस तरीके से बातचीत की जा रही है उसमें जैसे हमने देखा कि 377 जो है भारत में जो है मतलब एक तरीके से LGBTQ जो पूरा का पूरा समुदाय है वो लीगली प्रूव्ड है, लेकिन क्या वो शादियां कर सकता है तो वो नहीं। मतलब अच्छा, इस तस्वीर को थोड़ा बड़ा कर दीजिए जिससे साफ साफ देखिए, जिसमें चीफ जस्टिस ऑफ इंडिया जो है वो बैठे हुए हैं, इसके साथ साथ जो है और भी जो जस्टिस हैं वो बैठे हुए हैं। चीफ जस्टिस ऑफ इंडिया ने कई सारी व्याख्याएं करते हुए, अपनी बात को रखते हुए कई सारी बातों को ऐसा रखा जिसमें नई चीज़ों को जोड़ दिया। खास तौर पर क्वीर को लेकर जो उन्होंने कहा, जब हम LGBTQ पढ़ते हैं तो उसमें L का मतलब होता है लेस्बियन, B का मतलब होता है बाइसेक्सुअल, T का मतलब ट्रांसजेंडर, G का मतलब जो है गे, और क्वीर को लेकर उन्होंने जिस तरीके से अपनी बात को रखा उसमें उन्होंने साफ तौर पर कहा है कि ये अब सिर्फ और सिर्फ कोई अर्बन यानी कि शहरी मामला नहीं रहा है या फिर कोई एलीट क्लास के लिए ये बात नहीं रहा है। कोई भी व्यक्ति, कोई पुरुष या महिला क्वीर जो है वो गांव में भी हो सकती है। ये बात जब कही गई तो एक बड़ा जो है संदेश दिया गया है कि अब LGBTQ जो है वो सिर्फ बड़े शहरों का मसला ना रहेगा। सेम सेक्स पर सुप्रीम कोर्ट का फाइनल जजमेंट जो है वो हो रहा है। शादी स्पेशल मैरिज एक्ट में रजिस्टर करा सकते हैं, ये बड़ी खबर है। जीवन साथी चुनने की आजादी होनी चाहिए, सुप्रीम कोर्ट ने कहा है। ब्रेकिंग न्यूज है इस वक्त की, जीवन साथी चुनने की आजादी होनी चाहिए। संसद देखे स्पेशल मैरिज एक्ट बदलना है या नहीं, लेकिन ये जजमेंट जो है वो बहुत बड़ा है। फाइनल जजमेंट आया है और उसको लेकर जिस तरीके से फाइनल जजमेंट पढ़ा जा रहा है उसमें जो बड़ी खबर आ गई है कि शादी स्पेशल मैरिज एक्ट में किस तरह से बदलाव कर सकते हैं वो देखना चाहिए। जीवन साथी चुनने का अधिकार ये जो है वो होगा, यानी कि साफ तौर पर कह दिया संसद देखे कि स्पेशल मैरिज एक्ट में बदलाव करना है या नहीं करना है, क्योंकि कानून बनाना जो है वो उनका काम नहीं है, वो व्याख्या करना जो है उनका अधिकार है और इसको लेकर एक बड़ा जो है ये साफ तौर पर जीवन साथी चुनने की आज़ादी होनी चाहिए, सुप्रीम कोर्ट ये कह रहा है। स्पेशल मैरिज एक्ट को सिर्फ इसलिए असंवैधानिक यानी कि इलीगल नहीं कह सकते क्योंकि वो समलैंगिक विवाह को मान्यता नहीं देता है, ये DY चंद्रचूड़ ने कहा है। ये बहुत बड़ी बात है कि इसमें जो ये जजमेंट को लेकर बराबर जो सामने खबरें आ रही हैं और उसमें साफ तौर पर अब फाइनल जजमेंट में ये कह दिया कि जीवन साथी चुनने का अधिकार है, आज़ादी होनी चाहिए। और ये फाइनल वर्डिक्ट पढ़ना है, उनको सुना दीजिए जरा, हमारे साथी जितने भी हैं। ये सुप्रीम कोर्ट से सीधी तस्वीर आप सभी को दिखा रहे हैं और इस समय हम देख सकते हैं किस तरीके से जो एक बड़ी भीड़ है वो जो इस पूरी की पूरी लड़ाई को लड़ती रही है और वो इस वक्त अगर अपने इसको सेलिब्रेशन में भी देखते हैं तो एक बड़ा परिवर्तन जो है वो समाज में देखने को मिलेगा, क्योंकि सरकार ने जो अपनी तरफ से पक्ष रखा था उसमें कहा था कि जो भारतीय समाज है वो अभी इस एक्सेप्टेंस में नहीं है, जो इस समलैंगिक विवाह को जो है, देखो समलैंगिक जो है यानी कि जिस तरीके से जैसे मैंने बताया कि एलजीबीटी कम्युनिटी वो तो इंडिया में पूरी तरह से आज़ादी से रह सकते हैं, उसमें कोई दिक्कत नहीं है, लेकिन जो शादी की मान्यता को लेकर जो मांग बनती रही लगातार, उसको लेकर आज जो ये बड़ा फैसला हो रहा है, फाइनल जजमेंट जो है वो सुप्रीम कोर्ट से आ रहा है, उसे पढ़ा जा रहा है, सुनिए।
Iteration. Similarly, the sections addressing the union government's preliminary objections, that is the discussion on the court's authority to hear the case and that queerness is a natural phenomenon that is neither urban nor elite, are parts we have no hesitation in agreeing with. However, we do not agree with the conclusions arrived by the learned Chief Justice and the directions issued. We do not agree with certain premises and conclusions that he has recorded. They are: 1. That there exists no fundamental. We do agree with the premises and conclusions that he has recorded. They are that there exists no fundamental right to marry under the Constitution, that the Special Marriage Act is neither unconstitutional nor can it be interpreted in such a manner as to enable marriage between queer persons, and that transgender persons in heterosexual relationships have the right to solemnize marriage under the existing legal frameworks. We have briefly highlighted our main points of agreement and reasoned in more detail those aspects with which we cannot persuade ourselves to concur. We had the benefit of perusing the concurring opinion of Justice Narasimha. We endorse those observations and conclusions fully. The reasoning and conclusions shall be read as supplementing that of the present judgment. For long periods in many societies, the choice of a matrimonial was not free. It was bound by social constraints. Much of the time, marriage was seen as an institution meant for procreation and sexual union of spouses. In most societies, marriage had cast roles for the spouse. They were fairly inflexible, with men controlling most decisions and women placed in a subordinate position with little or no voice, and for the longest time, no legal authority, autonomy, or agency. For millennia, custom, tradition, and law subordinated wives to husbands. Notions of equality of partners or their roles were uncommon, if not totally unheard of. All these underwent radical change. Legislative activity is aimed at bringing about gender parity through prohibiting prevailing practices that further inequality and sometimes even criminalize certain customs, resulting in legislations such as Equal Remuneration Act, the Dowry Prohibition Act, introduction of provisions in the criminal law which gave teeth to such provisions, such as Section 498, Section 113A and B of the Evidence Act, etc. Other practices aimed at realization of social goals and furthering the mandate of Article 15(3) in respect of children, such as the right to free universal education under Article 21A, the Right to Free Education under Act 2009, the Child Labour Prohibition and Regulation Act 1986, the POCSO, what we call as POCSO, the Juvenile Justice Act, etc. In all these, the Parliament or concerned legislatures donned the role of reformers and furthered the express provisions of the Constitution, enjoining state action in furtherance of Articles 15(2), 15(3), 17, 23, and 24. Marriage has historically been a union solemnized as per customs, a personal law tracing its origin to religious texts. Legislative activity in the personal law field so far has been largely, though not wholly, to codify prevailing customs and traditions and regulating them only where needed. The instances that stand out are the enactment of the Succession Act, the Hindu Women's Right to Property Act 1937, the Hindu Marriage Act, the Adoptions and Maintenance Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Indian Divorce Act. As amended, the Muslim Personal Law Sharia Application Act and the Anand Marriage Act 1909. These laws mostly codified traditions and customs which existed, and also, to an extent, regulated marriages and succession laws. They also sought to introduce reforms. For the first time, monogamy was enacted as a norm applicable to all Hindus. Likewise, the option of divorce was enacted together with grounds on which other remedies such as judicial separation and maintenance could be sought. Further, the minimum age of marriage was also enacted through provisions in various personal laws and enforced through the Prohibition of Child Marriage Act. Thus seen that two kinds of legislations have regulated marriage. The first, like SMA, HMA, the Hindu Disabilities Removal Act and the Hindu Widows Remarriage Act removed barriers and enabled exercise of meaningful choice, especially to women. The second kind of laws are those which enacted restrictive guidelines, essentially to further an orderly society or to protect women, define minimum age for marriage, child marriage restraint, marriage of individuals within prohibited degrees of relationships, etc. Whereas some restrictions, in a sense, codified and recognized existing customs, such as being enacted by enacting prohibited degrees of relationships, the rule against insanity, rules enabling declaration of nullity or divorce on ground others were meant to further interests of women and children. Such reforming and codification, however, did not cover the entire field. For instance, in the field of succession and inheritance, the Hindu Succession Act enacts only certain broad features, leaving untouched the rights of various communities and sections of Hindus to work out their rights in succession to joint family and co-parcenary property. And this unwritten codified law is enforced not only in regard to inheritance, but also in the field of taxation. Likewise, the law accommodates and accords primacy to customs. Similarly, also recognizes customary divorce amongst Hindus. Neither the Hindu Marriage Act nor the Hindu Succession Act apply to members of tribal communities. In the latest three-judge bench decision in Revana Siddhappa versus Mallikarjuna, this court clarified that with the enactment of Section 16 of HMA, the legitimacy conferred upon children born of void or voidable marriages would be that they are entitled only to a share in their parents' property, but cannot claim it of their own right, as a consequence of which they cannot seek partition during the lifetime of their parents. The court also held that they cannot claim any rights other than what was expressly provided for. Thus, uncodified law and custom was upheld. The role of the legislature has been to act as a codifier and in many instances not enact or codify existing customs or practices, and wherever necessary intervene in furtherance of Articles 14 and 15(3) to enact laws. Parliament has intervened and facilitated creation of social status, this is marriage through SMA, and enabled the creation of the institution of adoption, which was available amongst only certain communities. These and other legislative interventions are the result of the state interest in reforms or furthering the interests of given communities or persons. For these reasons, we do not particularly subscribe to the characterization of democratizing intimate zones as discussed in the learned Chief Justice's opinion. These outcomes were driven by enacted law. Furthermore, there was state interest which impelled regulation of such relationships, as for instance, ensuring that minimum marriage age for girls. Likewise, there is state interest in regulating what kind of relationships, that is, prohibited degrees of relationship, should be enacted as disqualifications to marriage. Then there is a discussion or summation of the jurisprudence on Article 21 and the various facets which this court has recognized, such as privacy, choice, autonomy, and dignity. Then we move on. The court's intervention in oft-cited decisions on behalf of the petitioners has been to protect citizens or those approaching them against threats of violence. The instances are Shakti Vahini, Lata Singh, Shafin Jahan, Lakshmi Bai Chandragi, etc. These decisions were based on the state's duty to protect citizens and enable the exercise of their individual choice. in the face of threats. Other decisions, that is Joseph Shine, Navtej, and independent thought, were instances where specific provisions that criminalized or made exceptions to criminal behavior were struck down or read down in the enforcement of fundamental rights. That is Articles 14, 15, and 21. Along the way, Puttaswamy articulated the broadest right to privacy, which embraces within its fold the right to exercise one's choice of a life partner and to lead the life free from external barriers. This court has recognized that marriage is a social institution. As elaborated in Part 1, marriage existed and exists historically and chronologically in all of the senses because people married before the rise of the state as a concept. Therefore, marriage as an institution is prior to the state, it precedes it. The status is still not one that is conferred by the state, unlike the license regime in the US. This implies that the marriage structure exists regardless of the state, which can later utilize or accommodate but cannot abolish it. Under this view, terms of a marriage are set to a large extent independently of the state. Its source is external. That source defines the boundaries of marriage. This implies that state power to regulate marriage does not sit easy with the idea of marriage as a fundamental right. In attempting to analyze the claim to fundamental right, there are two primarily competing claims about the nature of marriage. One being that the state should exercise more control over marriage to support traditional purposes and perceptions. This is the quotation. And the other, that each individual should have the right to define marriage for themselves. If indeed there is a right to marry, unless it is elevated to a right akin to Articles 17, 23, and 24, which apply to both state and non-state agencies, and are cast in positive, in fact, emphatic terms, it cannot be operationalized. These provisions most emphatically create positive obligations. Likewise, Articles 15.3, 15.4, 15.6, as well as 16.4, 16.6 highlight state interest in creating conditions to further the goal of non-discrimination. Yet the previous decisions of this court have carefully held such provisions to enable the state and in the sense oblige it to take measures, but ruled out court-mandated policies and laws. In our considered opinion, this is not, however, one such case where the court can make a departure from such a rule and require the state to create social or legal status. What is being asked for by the petitioners is state intervention in enabling marriage between queer or non-heterosexual couples. Civil marriage or recognition of any such relationship with such status cannot exist in the absence of a statute. The demand hence is that of a right of access to a publicly created and administered institution. There is a paradox here or a contradiction which runs to the root of the issue and weighs on this court's mind heavily, in that the creation of the institution here depends on state action, which is sought to be compelled through the agency of this court. All decisions relied upon, Puttaswamy, Navtej, Shakti Vahini, and Deepika, contain broad observations with respect to individuals' choice of their partners, and also a reference to non-conventional relationships. Some observations are undoubtedly to be found in these judgments that cannot be referenced to hold that a right to marry automatically flows from the manner of the provisions of Part 3 which the petitioners assert. There cannot, for the above reasons, be a per se assertion that there exists an unqualified right to marry, which requires treatment as a fundamental freedom. We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry. While we agree that there is a right, which we characterize as a right to a relationship, which is recognized in Navtej, that the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21, as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and the other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely and express this choice undisturbed in society. Whenever the right to enjoyment of such relationship is under threat of violence or coercion, the state is bound to extend necessary protection. That is the natural consequence of this court's judgments in Navtej, Puttaswamy, etc. If it is agreed that marriage is a social institution with which the state is unconcerned, except to the limited state interest in regulating some aspects of it, does it follow that any section of the society, leaving aside the issue of rights of non-heterosexual couples, which wishes for the creation of a like social institution, or even an entry into a zone which is not popular or otherwise does not fall within the institution of marriage, can seek relief of its creation by court intervention? In the draft circulated by the learned Chief Justice, the reasoning that there is no fundamental right to marry and thereafter, nevertheless, to proceed to delineate the facets of features which unions other than marriage are deprived of, merits a closer look. The summation of various rights which such couple is said to be deprived of is used to delineate the contours of the right to enter into a union and justify a positive obligation. There cannot be any doubt that individuals have the choice of their life partners and the right to live the lives they wish to undisturbed. This is the essence of what this jurisprudence of this court has been. That is, explanation of the right to life and other rights enumerated or discovered by the interpretive process, privacy, choice, dignity, etc. Repeatedly, the decisions of the court have emphasized on the non-discriminatory and positive content of certain fundamental rights. In fact, the court has underlined the obligations of the state to create conditions conducive to the exercise of the right to equality and to realize fraternity. Refer to the decisions in Thomas and Indira Sani, which expanded the understanding of substantive equality, though without making enabling provisions enforceable by the court. This court also in some decisions accepted the argument that given the nature of fundamental rights and their evolving content, in many circumstances, it might be necessary for the state to intervene and protect the fundamental right concerned, thus creating an atmosphere conducive for the enjoyment of such right. Lata Singh dealt with honor killings of couples. In Arumugam Sirvai, the issue was virulent caste slurs and violence, which were crimes. The court required administrative and police officials to take strong measures to prevent them. In Shakti Wahini, Shakti Wahini dealt with threats by Khap Panchayats, and the court held that the state is duty bound to protect fundamental rights, and an inherent aspect of Article 21 of the Constitution would be the freedom of choice. The court issued directions. The judgment of the learned Chief Justice propounded a theory of a unified thread of rights, entitlements flowing from it, and how lack of recognition results in deprivation of specified rights under